Welcome back for lecture 7.2. We're going to talk about how the Supreme Court works and how really the federal court system works in general. So the federal court system is basically a three-tiered model. There's the U.S. district courts, and those are trial courts of general jurisdiction, and then various courts of limited jurisdiction. The U.S. Court of Appeals, which is the Intermediate Court of Appeals, and the United States Supreme Court, of course. So, unlike state court judges who are usually elected, federal court judges, including the justices of the Supreme Court, are appointed by the President of the United States. And so, of course, that's subject to the approval of the Senate. So, all federal judges receive lifetime appointments, and that is because Article 3 of the Constitution says that they, quote, hold their offices during good behavior. So on the lowest tier of the federal court system are the U.S. district courts, or federal trial courts. And these are courts in which the cases involving federal laws begin and a judge or jury decides that case. Every state has at least one federal district court, and there's one in the District of Columbia as well. So in the federal court system, there are 13 U.S. courts of appeals, and those are often referred to as the U.S. Circuit Courts of Appeals. And the federal courts of appeals for 12 of the circuits hear appeals from the district courts located within their respective judicial circuits. So the Court of Appeals for the 13th Circuit is called the Federal Circuit, and it has appellate jurisdiction over certain types of cases in which the U.S. government is a defendant. So the decisions of the Circuit Court of Appeals are final unless a further appeal is pursued and granted. And in that case, the case would be brought to the Supreme Court. So although the United States Supreme Court reviews a very small, so minuscule percentage of the cases that are decided in this country, its decisions affect the whole criminal justice system. So the court has addressed nearly every important facet of criminal law. And the Supreme Court makes criminal justice policy in two different ways: through a judicial review and by virtue of its authority to interpret the law. So judicial review refers to the power of the court to determine whether a law or action by the other branches of the government is constitutional. Not right or wrong, constitutional. So really, the Supreme Court is the final interpreter of the Constitution, of the law. And the Supreme Court also has to determine the meaning of certain statutory provisions if they've been applied to specific situations. So the United States Supreme Court consists of 9 justices, a Chief Justice, and 8 associate justices. The Supreme Court has original or trial jurisdiction only in rare instances. Most of the court's work is done as an appellate court. It has appellate authority over cases that were decided by the U.S. Court of Appeals, as well as some other cases decided in the state courts. So how do cases get to the Supreme Court? There is really no absolute right to appeal to the United States Supreme Court. I think that's a misconception. A writ of cert, or certiorari, I can never say it, certiorari, I can never say it right, you guys, so I apologize. And it says, even in my lecture notes, a pronunciation, certiorari. I don't know. I call it a writ of cert. And what happens here is the Supreme Court orders the lower court to send it to the record for a case for review. And more than 90% of the petitions for these writs of cert are denied. The court will not issue a writ unless at least 4 justices approve it. This is called the Rule of Four. So although the justices are not required to give their reasons for refusing to hear a case, frequently the discretionary decision is based on whether the legal issue involves a substantial federal question. So, like other appellate courts, the Supreme Court normally does not hear any evidence. The court's decision in a particular case is based on the written record of the case and the written arguments, the briefs, that the attorneys submit. The attorneys also submit oral arguments, which are arguments that are presented in person rather than on paper to the court, and after which the justices will discuss the case in conference. The conference is strictly private. Only the justices are allowed in the room. So we talk about majorities and pluralities. So when the court has reached a decision, the Chief Justice, if in the majority, assigns a task of writing the court's opinion to one of the justices. When the Chief Justice is not in the majority, the most senior justice voting with the majority assigns the writing of the court's opinion. And this opinion outlines the reasons for the court's decision, the rules of law that apply, and the decision. And from time to time, the justices will agree on the outcome of a case, but no single reason for that outcome gains 5 votes. So when this occurs, the rationale that gains the most votes is called the plurality opinion. Plurality opinion. Oops, I'm getting a little ahead of myself here. So let's talk about concurrence and dissent. So often one or more justices who agree with a court's decision may do so for reasons that are different from those outlined in the majority. And these justices may write concurring opinions, setting forth their own legal reasoning on the issue. And frequently, one or more justices disagree with the court's conclusion, and they may write dissenting opinions. And that outlines the reasons why they feel the majority erred. So one attribute of Supreme Court justice and a criminal trial judge in any small American city do have in common is the expectation that they will be just. When the other courtroom contestants rise at the entrance of the judge, they are placing the burden of justice squarely on the judge's shoulders. So one of the reasons that judicial integrity is considered so important is the amount of discretionary power that the judge has over the court proceedings. So before a trial, there's a lot of work that's done by a judge before the trial even starts, and it's free from public scrutiny. He or she is going to determine whether there is sufficient probable cause. Is there sufficient probable cause to authorize, search and seizure or electronic surveillance? He's going to really be looking at the evidence and make sure that there was enough evidence. And the judge is going to take on this role pre-trial as a negotiator because the defense and the plaintiff are going to be bringing different pre-trial motions to the court. So throughout the trial process, the judge spends a great deal of time in his or her chambers or their office where negotiations are happening with the prosecutors and defense attorneys. When the trial starts, the judge is more of a role of a referee. And in this role, he's responsible for seeing that the trial unfolds according to the dictates of the law and that the participants in the trial do not overstep any boundaries. He's really playing this referee role. The administrative role that a judge plays is based on the day-to-day functioning of the courts. So the primary administrative task of a judge is scheduling. So courtrooms have dockets or calendars, and it's the judge's responsibility to keep the docket current. Judges must also track immense paperwork that goes with cases and manage the various employees of the court. So how are judges selected? We talked about, the president selecting them when we're talking about the Supreme Court or more at a federal level. But it is difficult to make a general statement about how judges are selected in state court systems because it varies from state to state. So in some states, such as New Jersey, all judges are appointed by the governor and they are confirmed by the upper chamber of the state legislature. In other states, such as Alabama, there are partisan elections that are used to choose judges. And usually, what happens in these cases is a judicial candidate declares allegiance to a certain political party before the election. In other states, such as Kentucky, they conduct nonpartisan elections. And so this says basically that a judge does not have to affiliate themselves with the political party. It's separate. So in 1940, Missouri became the first state to combine appointment and election in a so-called merit selection process. When all the jurisdiction levels are counted, 19 states and the District of Columbia now utilize this Missouri plan, and it's a merit selection. And it has the following steps. So candidates are nominated, and they are nominated by a nonpartisan committee of citizens. And the names of the 3 most qualified candidates are sent then to the governor or the executive of the state judicial system, and then that person decides or chooses who's going to be judge. And a year after the new judge is installed, a retention election is held, and then that's where the voters decide whether they're going to keep that judge or not. So overall, about 58% of all state appellate judges are white males. But in many states, members of minority groups are underrepresented in comparison to the demographics of the general population. So I'm going to give you, for this next one, we're going to go through some of the organizations or some of the work groups that happen in the courtroom. So a courtroom work group refers to the social organization consisting of the judge, prosecutor, defense attorney, and other court workers. But the most important feature of any work group is that it is a cooperative unit. The members need to have shared values and methods that help keep the group working efficiently. So, of course, in the courtroom, the work group, the most prominent member is the judge, the prosecutor, and the defense attorney. So there are also 3 other court participants that complete the work group, and that's going to be the bailiff. Where are we? I think we have slides on this, so I'm just going to go over this. The bailiff of the court is responsible for maintaining the security. Bailiffs lead the defendant in and out of the courtroom. Bailiffs are often members of the sheriff's department, and sometimes they're employees of the court, but usually they're part of the sheriff's office. The clerk of the court has so many responsibilities. Any plea, motion, or other matter to be acted on by the judge has to go through the court. Any sort of paperwork that comes in during a trial goes through the court clerk. There's also court reporters, and they're the ones that are recording every word that is said during the course of the trial. So, as I said, the judge is the most dominant part of the work group. So then we move into the prosecution. And public prosecutors are defined as individuals that are acting as trial lawyers, and they're initiating and conducting cases in the government's name on behalf of the people. In cases that are tried in state or local courts, the public prosecutor can be referred to as prosecuting attorney, state attorney, district attorney, county attorney, city attorney. And in each of those cases, they are the prosecutor. So they have a duty of fairness. And in some jurisdictions, the district attorney is the chief law enforcement officer with broader powers over police operations. But prosecutors have the power to bring the resources of the state to bear against the individual and hold the legal keys to vetting out or withholding punishment. One of the rules is the Brady Rule. And to lessen the opportunity for improper behavior by prosecutors, the United States Supreme Court established this rule called the Brady Rule more than 50 years ago. And this rule holds that prosecutors are not permitted to keep evidence from the defendant and his or her attorneys if it's going to be useful in showing evidence. Huge part of being a prosecutor is making sure you're following the Brady Rule. So when he or she is acting as an officer of the law during the criminal trial, there are limits on their conduct. So during the pre-trial portion of the trial, prosecutors have a lot of discretion in deciding a lot of different things. Whether that individual will be charged, the level of the charges to be brought, if and when to stop the prosecution. They're looking at the case from a different standpoint than law enforcement is. Where is this case going to go if it goes to trial? They're looking at many different things. And so even though the Attorney General is the chief law enforcement officer in any state, he or she has limited control over the prosecutors that are in those other state boundaries. Each jurisdiction has a chief prosecutor, and usually those are appointed, but sometimes elected as well. So this goes through just if the prosecutor is an elected official and how that works. But let's talk about the defense attorney. So the defense attorney is defined as the lawyer representing the defendant. Sometimes we know this as a public defender, or there can also be a private attorney as well. So acting as this advocate for the client, the defense attorney is ensuring that the government is proving every point against the client, and that's going to be proved beyond a reasonable doubt, even if the case does not go to trial. And so they can have a number of responsibilities. They can be doing the investigation. They're wanting to make sure that they have everything done for preparing the case for trial and defending the person who they are representing. All the responsibilities are listed here on the slide. So the most important responsibility, though, that I want you guys to know is that they need to be an advocate for their client. The attorney is obligated to use all ethical and legal means to achieve the client's desired goal. And that's usually, of course, to avoid or lessen punishment for the charged crime. So the public defender is one who works for the government. So a public defender is hired by the state or the county and make sure that they're basically hired to be the representation of what the Sixth Amendment says. Talks about the Supreme Court ruling Gideon versus Wainwright in 1963. And although the Supreme Court's Gideon decision obligated the government to provide attorneys for the indigent, poor defendants, it offered no guidance on how poor the defendant needed to be to qualify. So in theory, counsel should be provided for all those who are unable to hire an attorney without substantial hardship. But in reality, each jurisdiction has its own guidelines as far as how that's determined if you qualify for a public defender. So you might be refused counsel in one area based on your income or situation, but in another area, you might be able to qualify for one. So in most cases, the county's government is responsible for providing the public defenders. And these three different methods are often used by different counties to establish how public defenders will be allocated to clients. I want to make sure that you guys are aware of this attorney-client privilege. And what this is a rule that basically says an attorney has to have access to all the facts concerning the case, even those that may be harmful to the defendant. And to promote this unrestrained flow of information between two parties, legislatures and lawyers themselves have constructed the rules of attorney-client privilege. And these rules require that communications between a client and his or her attorney are confidential, unless the client consents to the disclosure of the information. So attorney-client privilege does not stop short of confessions. So indeed, if on hearing any statement that points towards guilt, the defense attorney could alert the prosecution or try to resign, the attorney-client privilege would be rendered meaningless. So they can sit there and tell their attorney that they did commit murder or they did do this crime, but that falls under attorney-client privilege. So there is exception to the privilege. And the scope of this attorney-client privilege is not all-encompassing. So in 1989, United States v. Zolan, Supreme Court ruled that lawyers may disclose the contents of a conversation with a client if the client has provided information concerning a crime that has yet to be committed. So if it's not been committed yet, they can talk about that, but it applies only to communications involving the crime that's ongoing or might occur in the future. All right, guys, this is a long chapter, covers a lot. I would recommend that you jump onto YouTube. There are some great videos that talk about the Supreme Courts and how it's set up, some graphics. Do a little bit of your own studying when it comes to the court system so you can better understand it.